Boss Construction, your South Florida permitting and code compliance specialist. This is one of my cool interviews that I like to do with a good friend and colleague of mine, Kevin Plotkin with Express Title. What's up, man?
Hey, Ben. Good
How's
to
it going?
see you. Good.
Thank you for being here.
Yeah, thanks for having us.
We actually work together on so many cases, which is interesting. And then through that, we understand consistent problems that we're seeing. Really early on in my resolution days. How long have you been in the business for?
Well, we've had our own company now for 7 years.
That's awesome.
Yeah, and obviously I have a lot of experience prior to having my own company, so been doing this for a long time.
Now, tell me again, I've heard most agents out there, my family's agents. Again, you're an attorney-owned and operated title company.
Yes.
What does that mean for your clients?
It means a lot. So we have an affiliated law firm, Plotkin Law Firm, and Express Title Services is our title company, both in the same office. And in Florida, believe it or not, you don't have to be an attorney to have a title company,
Correct.
Which to me is crazy. I still see how crazy that is because when we're dealing with companies on the other side that are not attorney owned and operated, it makes the job more difficult because a lot of times they are not doing things properly and we have to hold their hand through the transaction. And as an attorney from a legal standpoint, I'm putting out fires in real estate deals left and right all the time from a legal perspective.
Yeah.
So when that's not present, I don't know how that happens. In fact, I do know it doesn't happen. It's crazy, and sometimes they need to go to outside companies or when the going gets tough and legal situations arise, whether it's a contractual issue between the parties or whether it's a title condition that's overly burdensome and we need to, from a legal standpoint, explain to the title underwriter why it's unnecessary. We are able to do that in-house and get deals closed where others couldn't, but when there's not an attorney involved and those situations arise, well then they're stuck and they need to go to a different company now and they all of a sudden need to find outside counsel and start scrambling around for other professionals to get involved, whereas with an attorney-owned and operated title company, we're already there.
I've seen with some of the non-attorney owned and operated, some of them have in-house attorneys, but then it was very interesting to me that, and I got this feedback from other people, that once they had to bring in the other attorney, that was on top and more money, and you're a one-stop shop.
Exactly. So you get the benefit. Our fees are very competitive. We charge less actually than some non-attorney owned and operated title companies. So with us, you're getting that benefit wrapped into one service.
Let's talk about, because a lot of our viewers are South Florida property owners, real estate professionals, people selling their property. Let's just talk about the contract. Anything, in relation to knowing about permitting and code violations early, what can people also put in their contract to protect themselves if they're the buyer or the seller? Can you go over some of those things with us?
Definitely. So you mentioned the word contract, and it's a great buzzword because, and we talked a second ago about the benefits of having an attorney-owned and operated title company. A real estate transaction, it's a legal transaction. It is controlled by a contract, which is a legal document. So that goes right there to explain basically one very big benefit of having an attorney involved in the transaction is at the basics, at the contract level between the parties. So the Florida real estate contract that is most commonly used, the as-is contract, it discusses what happens if we are to discover permitting issues or code violation issues on the property when we are doing our title work and vetting the property and doing those searches to see if those issues are present. And one of the big changes to the contract and one of the issues that we see are that actually the language that's in the contract is written such that if there is an open or expired building permit found, actually what the seller needs to do is to cooperate in getting it fixed. What that means is provide any documents or plans that they may have in their possession regarding the work that was done, and they need to allow access to the property for proper inspections to be done in order to close out the problem. Except the one thing that it does not require the seller to do is the most important thing, which is spend any money to fix the issue. So,
which every situation is different, every amount of to resolve. I mean, I even know on the permit resolution side, again, based off the jurisdiction and the deficiencies in the property. So what is an agent or a seller to do?
So one of the things that we can do is we insert language into the contract that overrides the standard language that's already in the contract, so that we can make it so, and we can alter it so that the seller does become financially responsible if there is an open or expired building permit.
So you're talking about like page 10 or 11 or an addendum where that
right, and the additional terms, we can add that in so that we can protect a buyer from the situation where now an open or expired building permit is found, right?
After if it's found, sometimes they're found, you guys order the lien search right away, day one when you get the contract, but sometimes by the time the search gets back, they're outside the inspection period.
Exactly. So just to make sure everyone's clear on everything, the inspection period is the ultimate point in the contract where the buyer, during the inspection period, the buyer can do their due diligence on the property, and they have the right to back out of the contract for any reason whatsoever.
If they don't like the way the property smells,
any reason at all, they change their mind, whatever it may be. During that
it's
inspection
a formality,
period,
basically.
During that inspection period, it's a free look. However, once the inspection period is expiring and it's ending, that's the ultimate point in time.
It's like dating, like. We're dating and there's a free look and we're going to go out
right,
to sushi room.
Just a quick coffee. Just a coffee.
Okay.
We're not married yet.
Okay, all right.
And so when we reach the end of the inspection period, that's the ultimate point in time where the buyer needs to make a decision. Are we really moving forward with this deal or not? Mm-hmm. And so after the inspection period ends, a buyer is locked into the contract. It becomes a lot more difficult for a buyer to change their mind and back out of the contract. So once we get to that point in time, we really want to have all the information for the buyer possible to be able to have them make the most informed decision that there is. So having that information, ordering the lien search and ordering the title searches on day one and finding out the information quickly is key for a couple of different reasons. We're going to find out the information early on so that if there are issues, we can start working on them right away, fast as possible, so there's no delays in the closing.
So basically, I've seen loan rate locks collapse, like different things with mortgages. For some reason, a buyer or seller, they don't want to extend a lease back. All these.
Yes.
You want the deal to stay on track.
Right, to move forward. So having the additional language that we talked on a second ago that alters the contract and makes it so that a seller is financially responsible if there are permitting issues found to correct them, that's one layer of protection.
And that's if you
key.
Represent the buyer.
Correct. Now, even though you have that language in there, and we know that if there's a permitting issue found, the seller is going to be financially responsible to fix it, that doesn't automatically mean that it's still advantageous for the buyer to find out the information during the inspection period, because it may not be a situation that the buyer wants to sign up for or get locked into. So if it's a permitting issue, for example, and it's going to take an extra 30 days for the seller to fix it, even though the seller is required with our new language to financially pay to fix that, it still may not be a situation that a buyer wants to wait around for, or they may have to get their kids registered in school. They may need to move quickly.
Also, every date is critical, because whenever the agent or the property owner calls me, they're sitting with a lien search in their hand for a couple days. They go to the city, they try and contact the previous contractor, and even if they are in business, unfortunately, because of South Florida and our business dynamic, it's hard to get people to do the right thing, and the cities keep issuing these guys permits when they have open permits. So it's pretty. So again, like 5 business days is wasted from when the attorney or title company, hopefully you're using attorney owned and operated one, when the title company gives the search to the agent, and then the agent comes to this problem to their seller.
Right. So that is exactly the length of time it could take just to get a municipal lien search back can be a long time in itself. So you don't want to delay in placing the order. For those of us out there, we're talking all these terms: open or expired building permits, municipal lien search. Let's so for those so we do a title search. That's going to search the public records for any encumbrances on the property, any clouds on the title that are recorded in the public records that we can see, such as liens, mortgages, judgments,
probate, those issues.
Those types of any probate issues that have gone on, any defects in the title.
Where the property cannot be conveyable.
Exactly.
With an open permit you can convey the property.
Perfect question. So then there's also that's a title search. However, municipalities or cities have lien rights in issues such as an open or expired building permit, code violations, unpaid utility bills. Those balances may be accruing in the city, but the city may have not recorded a lien yet in the public records, so a title search won't show us that. We have to inquire directly with the municipality. That's what
sometimes we see sometimes we see an open permit that isn't a code enforcement violation. It depends on where it escalated and the process within that.
Right, if it's been a long time, chances are the city has recorded a lien.
And sometimes we've seen
they don't do so right away. So in that case, that's why we have to check with the city in addition to checking the title records. Now, that's going to reveal permitting issues.
Yeah.
And you may have touched on this before, but in South Florida, the way it works with a permit, what an open or expired building permit is and you fill in here for me, but if you need to, a contractor will draw up plans for the work that's to be done. They are going to submit the plans to the city to show them. The city will look at it, make sure it's the code, and they'll issue the permit that allows the contractor to go begin doing the work. And then once the work is completed, what's supposed to happen is they're supposed to have a final inspection where the city comes out, looks at the actual work, make sure it's
sometimes there's many
right throughout. Thank you. Exactly.
All right, you got it, man. I like that.
Throughout the process. And at the end, though, there's supposed to be a final inspection where the city will come out, or inspections throughout the interim. They'll come out, make sure the work is good to code, it matches the plans, and they'll close out the permit. Unfortunately, in South Florida here, a lot of times that last step doesn't happen, and the permit remains open, or worse, it expires.
This was very interesting about me and you. Before I even met you, and when we first talked, you knew about this process. Meaning
100%.
Meaning because you were at the front lines for your clients, giving them a great level of service. And Yindra and your team and phenomenal people, you guys are handling this process.
So we are a boutique firm. There are large law firms who practice many different areas of law, anything from A to Z. But it's more of a general
That's like
practice.
The personal injury attorneys now saying we do insurance defense.
Right.
Or first party claims or whatever.
We do focus on a few limited areas, but we focus on them and we do them very well. And that's why the level of expertise is there when it comes to these particular issues that are more detailed, and the service as well. So at our law firm, we also handle corporate transactions or business matters, such as people buying or selling businesses. We also handle probate administration.
The reason why I'm laughing is because like an agent called me the other day and I'm like, well, what are you doing? They're like, Ben, do you know what an operating agreement is? I need to draft one. I said, you're drafting an operating agreement? This is obviously someone, and this is for residential, commercial. This is simply a residential property owned under the name of a corporation that needs to be conveyed, and XYZ title company is asking them to draft the operating agreement.
That is a perfect example of corporate issues or business entity issues coming up in real estate transactions. Also, like we talked about a second ago, if somebody passes away, they have to do a probate of the estate so we can determine in the courts who the rightful beneficiaries are that will inherit the property and then be able to sell it to somebody else. So those legal issues come up.
You don't want to end up in probate. You want to end up, because I've dealt with personal representatives and people like that after they've gone to probate, and that process is very, the idea of a will or someone passing is you don't want to end up in probate.
Right, but a lot of times you do, and the properties are subject to the probate process, which is a legal process that has to be complete in order for a beneficiary or the person who's inheriting it to be able to reconvey it. We need to know from a court that that person is now the legal rightful owner before they can sell it to somebody else. Similarly, if it's a corporation-owned property or an LLC-owned property, like you just talked about a second ago, there are documents that we need to show to prove up who the rightful officers of the company are, such as through an operating agreement to be able to sell the property. So those issues, they go hand in hand with real estate. They come up all the time. There's estates that own properties, there's business entities that own properties. So being an attorney that is familiar with those areas and a jack of all trades, so to speak, goes a long way in real estate transactions, because when those issues come up, if there's not an attorney involved, guess what? Now you need to go find one. So we're
sometimes there's time and days
and extra
involved
money involved. So having the knowledge of those areas blends really well to real estate transactions, because it comes up all the time. So we're able to resolve those. So, but those are legal areas, right? And being an attorney means that I'm familiar with those areas, my office is familiar, and we can do those in real estate transactions. But as we were talking about a second ago, when we order our title searches and our lien searches on day one of the contract to get the information immediately, we mentioned it's beneficial in a few different ways. Number one, we can start resolving the issues immediately, so there's no delays in closing. We are best suited with our expertise to actually know how to resolve the issues. But it also notifies the buyer of any situation during the inspection period that could cost a lot more time. So when those issues come up, we're able to best resolve them. Now, our municipal lien searches, however, they will reveal open or expired building permits or code violations.
And in the water, that's yeah.
And those types of issues, as you mentioned, I am very knowledgeable about.
Yeah.
We can talk about them. Yeah. We know about them. We know how to resolve them.
But some things, it's very interesting because some things are an administrative closeout, which we've talked about that, like the city's permitting systems did an update 3 times. Oh, we closed. And some things, the work is left in pieces, or it's complete and it wasn't inspected. And the city, at the end of the day, wants to collect their fees, and they want someone to take responsibility for the work. And if there are, such as a general contractor like myself, and if any threshold inspections were missed, like, for example, underlayment under a bathtub or shower pan, then they're like, you got to get an engineer. So it's in the city's mind, it's all like a hold harmless thing. And they want to be able to, from having worked at the city, they want to also be able to protect the continued residents and business owners. And that's why this afternoon I'm going to solve 3 reoccupancy things.
Right.
Where if you're one of our viewers and you've heard this before from me, but a reoccupancy inspection is where the city comes in to do an inspection to check for bed bath count, square footage, unpermitted work. Not open and expired permits, but unpermitted work. Mm-hmm. That didn't show up. So
no, definitely. So
and these are things you could be, proactive about and know where they're applicable.
Right. So to your point, real estate transactions are a dynamic thing. There's a lot of moving
Did
parts.
I switch places a little?
No, that's
Cool.
We're familiar with each other's businesses,
like
so we can speak on it. But so when we get to title issues or contractual issues, that we're so well suited to handle, and even municipal issues such as permits, we're knowledgeable about it. Sometimes it's just an administrative closeout. We can call the building department and work on it, but that only goes so far. To a certain point, when we get to more advanced permitting or code violation issues that require contractors to do work, or contractors to explain to a city inspector what wasn't done, what needs to be done to a new level, that's where we can only take it so far, and that's where we need to call and actually rely on other professionals such as yourself, because I'm not a contractor. Yeah. And when we get into more involved and detailed permitting issues, I'm not a licensed contractor to be able to go repair the work that needs to be done.
And also, what's very interesting in my experience, a general contractor is looking to do work. They're like, they see, he can replace kitchen and windows. Again, I kind of call myself like an owner's rep. Is that fair to say? Like a consultant. So someone who's coming in to look to, get inspections passed and get the city or the county off their back.
Definitely. So that while we do the best we can to do everything in-house that we need to do to get a real estate transaction closed, at a certain point there are issues that come up in the permitting and the code violation world that we have no choice but to rely on an outside professional who specializes in that area, such as yourself.
I have best practices, meaning an agent calls me and they're in Sunny Isles and they're in a condo and there's an open flooring permit, no subflooring or soundproofing inspection above the first floor. And they said, Ben, how are you going to permit our kitchen and bathrooms? And I'm like, we can't. No, I'm sorry. Back that up. They say, how are you going to close out this flooring permit? And I say, well, if I invite the city to close this open flooring permit and they see granite and marble and quartz and all this beautiful stuff that your owner did, they're going to light me up for unpermitted work.
Right.
So again, sometimes I think the information that we give, in that particular circumstance, what I told the agent is find a buyer to assume and explain to them and credit them some money. Again, I'm not looking to rebuild the castle.
Right.
I'm looking like you were looking to get the deal to the closing line, to give the seller, the buyer, and the agents the best advice.
Now, that situation, that example that you just mentioned right there, is where the information's known ahead of time, and like you said, find a buyer who it's disclosed to in the front end, they know about
Seller's disclosure?
Right.
Yeah.
Exactly. And the buyer is, that seller is knowledgeable about their issue and they're being upfront about it, and they're looking to find a buyer willing to accept it or willing to participate in a deal knowing upfront that issue. Contrast that with most other situations that happen where we find these issues after a buyer is already under contract.
Or after inspection period even.
Exactly.
Then you're in this really weird situation where you've had your right to inspect, your seller, the buyer's already negotiated with the seller for deficiencies, and then you're finding more deficiencies. And then that makes the transaction just throw it up in the air, you know?
Exactly, and anything can happen at that point, and buyers can become locked into situations that they don't want to be, and that is going to be just a bad situation for everybody. Nobody wants that, and buyers or realtors or even attorneys. Nobody wants that for their clients. So that's a way that we can definitely help avoid those situations.
That's an amazing best practice. I mean, that's something that you could do.
Yeah, no, definitely. And it's not only a way to protect buyers, to get them not locked into situations they don't want to be, but even more importantly, getting deals closed and assisting in real estate transactions to bring them to the closing table where others don't. And that's why having professionals like myself, having professionals like you involved in situations, it really goes such a long way. And your technical experience in the areas of permitting and code violations, I can personally say, has gone a long way in transactions where otherwise I don't believe it would have closed, but for our involvement and your involvement.
No, it's interesting. I have this little prop here from the Village of Biscayne Park.
This is real artifact.
This is a real artifact. It's not something that you use to do the drain line under your sink or someone tried to do it. It's not a pipe or anything like that. What it is, interestingly, is someone who just jimmied a sink up and put all these pieces together like my 3-year-old child.
Right.
So again, what's very interesting is in this house, it was a beautiful house in the Village of Biscayne Park. And again, one thing that I want to stress about Kevin and his firm is that this was a celebrity's house. This was an all-star agent, and it was handled professionally all throughout the way. We did...
And a difficult city.
Difficult city. It's a village.
Right.
And it's a log cabin. No, but so it's a little area, if you don't know, I think it's just... between North Miami Beach and North Miami with older housing stock. So the city says, hey, this wasn't the result of a reoccupancy inspection. This was the result of an absentee owner on the West Coast and a code enforcement violation for kitchen, bathroom, all interior remodeling without a permit. So that's kind of how we got brought into the picture. I'm not sure in this particular situation if the lien search revealed the code enforcement violation and then became a lien on the property, or the seller disclosed it. I'm not sure really how that...
No, it was the former. The seller did not disclose it, and so we had to discover it on our own, but nonetheless we were able to get through.
Did you come up with it in the lien search?
Yeah, early on.
Is that where you discovered it in your due diligence?
Yeah, early on in the process, as early as possible, and then lo and behold, that actually lended it well to getting the deal closed, because finding out about it early meant that took a lot of time to fix, and it took extra time that was needed to close the deal.
So it's very interesting. They removed walls, kitchen, bathroom remodel. They removed a stair railing, so the stair railing was kind of left loose and buckled. And so what was very interesting is the liens amassed to it was like $300 or $500 a day for electrical and structural. And what was very interesting about it is the cities don't negotiate before you bring the property into compliance.
Right.
So we ended up getting close to a $200,000 lien reduced to $7,500 after the property was brought into compliance.
Right, and then we also had altered the contract so that the seller whose property it was responsible for making that payment.
Yeah.
And the buyer was not locked into that situation.
Had that language not been in there, outside the inspection period, what would have happened?
There is a chance that the buyer would have been in a very bad situation. They're inheriting, locked into a contract where they're inheriting a headache from somebody else's property that they're buying, that not only requires work to be fixed, but extra money that they have to spend. And let's face it, that's not a happy customer.
They're hard at that point. Hard meaning their deposit is solid. They're not happy. $60,000. Say it's a 10% or 15% deposit.
Right, and that's if the issue's found and brought up all together. You'd be amazed what I see happen. The stuff that we see slipping through the cracks with other companies out there and other closing agents that doesn't even get brought up.
It's very interesting because all day I'm presented to sellers, and sellers are like, "Hey, I didn't know there was open permits when I bought this GL home in Miramar or this house in Pinecrest." And they go back, they look at the municipal lien search, they look at all their papers, and it's not on there.
Right.
So again, this isn't really what I like to explain to the current property owner in the hardship situation, but when your house is under contract and you didn't find out about it early on, the best thing, what you have to do is just deal with the problem at hand. Even if the contractor's in business, good luck getting them back to try and remedy these things. And that brings me into, one of my best practices, and agents are doing throughout South Florida, is they're pulling lien searches really early, before they even take the listing. When they take the listing, the property owner, the agent, they're pulling the search to find out the deficiencies. Because sometimes if you're under contract for 30, 45 days, and the lien search is ordered first day with Plotkin, Mr. Kevin over here, amazing. Sometimes if the contract's only 30 or 45 days, the lien search takes 10 business days to get back, and then
longer.
And then we're left.
Yeah, and it's not only finding the issues early, but actually knowing how to resolve them.
Yeah, having it in your toolbox, knowing, and again, that's what we like to do. Again, we like to help agents and sellers.
Exactly, and we're looking to protect the parties in the real estate transaction, whether it means we're going to battle and correcting issues on technical things that we are experts at, or we need to rely on other parties for something that's outside of our professional area of expertise that we're licensed to do, such as a further detailed code or permitting issue that we need to rely on. So it's really having the proper professionals and the relationships and the team around you that really goes a long way.
And some of these commercial lien searches, I got the chance to review one of Reliables from Tamarack and Miami Gardens. I mean, not only do they involve multiple jurisdictions, but they're 140 pages long, showing when it was ordered, the results of the ordering, and sometimes for 22 tenants, they make you pull 22 searches. It could be thousands of dollars. So it's very important to have the information, know what the information costs, and what the turnaround time is. When you get the searches right away, you review them, right?
Of course. Not only are we reviewing them ourselves, but we're also sending a copy to the buyer or seller and agent so that they have it for their records, whether it's clean or not. In addition to that, we're updating all of the parties to let them know the results, whether they're good or bad. So if it's good, the email to everybody will let them know. Great news, we got our lien search back, or we got our title search back, and it's clean, nothing to worry about. Or we got the results back, here's the issue, here's what we're doing to fix it, and here's how long we think it's going to take. Or here's the issue, we don't know how long it's going to take, but we're working on it, and we'll get back to you as soon as we have more information.
Let's do our due diligence. Let's get to the closing table. Whether it's handling the problem pre-closing or post-closing, just making sure that all parties are represented.
And that they know what's going on so they're not left in the dark with any last-minute surprises.
What is the worst... last question. What is the worst? I'm having so much fun here, so I don't know.
Shoot.
It's natural. What is the worst commercial, industrial transaction that you've seen? Like, for example, I've seen in West Park, the guy goes to sell his warehouses, and all of his tenants have a violation for no local business tax receipt or occupational license.
Right.
And one thing triggers another. With the city. What's the worst things that you've seen?
We have seen, well, when you're dealing with a commercial property like that with tenants, the process that is supposed to happen in these transactions, if done properly, is at the beginning of the transaction, we're going to get copies of all the leases with those tenants between the current owner and the current tenants. Because we want to review them. We want to see what the terms are. We want to see how much the rent is. We want to see
security transferred over.
Right. We need to. When you're buying a property like that, you're buying those tenant relationships. You're taking over those leases. So it's very important that we inspect and we know everything there is to know about those relationships. So the landlord or the seller, the current property owner, is going to give us copies of the leases. With all the pertinent information on it. And that seller is most likely going to tell you, these are all the greatest tenants ever, they all pay their rent on time, we've never had any problems.
Our return on investment is 18%,
Now, we're not in the business of trust. The old saying, trust but verify.
Yeah.
So
we're not in the business of sales. We're not salespeople.
Right. So we need to get, in that situation, we need to get both sides of the story. Yeah. So the landlord or the owner is going to give us copies of the leases, but then we're going to get tenant estoppel form. We're going to get a questionnaire filled out by the tenants to see what they have to say to make sure
Have you ever seen the lease and the landlord-tenant estoppel on the tenant side conflict?
All the time.
Yeah.
And that's the real point of it. So the landlord will tell us, they gave us a $2,500 security deposit only. And the tenant will say, well, what are you talking about? I gave you a $5,000 security deposit.
Yeah.
Or we want to know if the tenant has any current claims against that landlord or current owner that we would want to know about because we're buying that relationship.
Yeah.
So we also want to have the tenants not only fill out the questionnaire, but we also require that they have it notarized so that we know that it's the tenants filling it out and we're legitimately getting both sides of the story. Now, to your question, what's the worst thing we ever saw? Well, we had a situation where a current property owner gave us leases with false information on it, and this wasn't a deal we were handling at the beginning. It actually came to us later because, believe it or not, a lot of the work that we do is cleaning up messes that were made elsewhere.
Yeah.
Right? But what had happened in that situation was the landlord gave copies of the leases, and then instead of having the tenants fill out the tenant estoppel forms, the landlord faked the tenant estoppel forms, filled them out themselves to match the false information in the leases, and then forged the signatures by the tenants.
In South Florida?
Yes, yeah, exactly. This is the type of stuff we see going on here, and that's one of the reasons why.
We have a lot of we have a lot of absentee owners. We have a lot of property managers who are, quasi, they're offhand kind of, and sometimes they don't know. Like, for example, I was dealing with a commercial property, and they had so much unpermitted work done in their office condo, and they built the kitchenette, and in between when the property was under contract and inspection period, that pipe that they dragged from there to there blew.
Wow.
And the second... So what are... And I know we're not able to shoot on things that on commercial leases I see on the municipal side. Tenant did not get a local business tax receipt. Tenant tried to get one and they found unpermitted things. And you do commercial.
Yes.
Commercial leases too.
Commercial leasing, commercial sales.
And again, these aren't. And these aren't like what I try and tell people is most of our situations, they're not copy and paste situations.
Right.
Every situation is different, and you don't want to end up in litigation.
Correct.
You don't want to end up losing money or losing a tenant or losing income. So you're here to prevent that.
Or being told by a property owner the terms of a lease and then having a forged document on behalf of the tenant confirming that lie.
So did that, in this particular situation, was like the security transfer put on the hut? Like, did it go? Did it close?
Right. Well, thankfully, once we were able to get involved, it did. But what was basically in a closing, if there's a security deposit that the owner has, that security deposit
is there something to protect the buyer at that point?
As a product from that situation, seeing that type of action go on, we now require that the tenant estoppel forms be notarized by the tenant. That way, you avoid a situation where a property owner is lying in the leases and then swearing by it by signing off on a fake tenant estoppel form. And what happens in these transactions is
you're in tens of thousands of this could amount to a lot of money, a little bit of money.
A lot, because the security deposits are transferred to the new owner. So, for example, if a property owner tells us, okay, the security deposit was $2,500. Then that's not verified. That amount is not verified by the tenant. Well, at closing, the security deposit is transferred to the new owner, so the new owner has it, so that when the tenant goes to move out, in case there's damages, they can tax that security deposit and keep some money. Or if there's no damages, they have to refund the money to the tenant that's moving out. So, for example, if the landlord falsely says the security deposit was $2,500. That's $2,500 that gets transferred to the new owner at closing, so they have that money. Then when the tenant goes to move out, the tenant says, hey, where's my $5,000 security deposit? Right, so that's really the point of why.
And also some of these, it's very interesting because when I talk to you, some of the transactions involve cash. Some of them are a mortgage. There's SBA loans involved. There's a lot of moving parts.
Definitely. We do represent lenders in transactions as well.
And will you represent the seller?
Of course.
So for example, if it's in like Palm Beach or Miami-Dade, the buyer under the regional provision, the Miami-Dade, in Broward, the buyer choose.
Right. In Miami-Dade and Broward, the buyer.
Is that just with residential or with commercial?
It depends on what the contract says.
Yeah.
Customarily, not by law, but customarily in Dade and Broward County, the buyer chooses the title company. But even in that situation, we can represent the seller and help them. And a lot of times, as a listing agent or as a seller, it's very beneficial because when the buyer chooses the title company, that's outside of your control. They can choose anybody they want. And there's a lot of bad title companies out there. And that don't know what they're doing.
Or you might get a file transferred to you that there were a lot of problems with.
Right, and that's when exactly cleaning up messes that were made elsewhere. But to answer the question,
you're like botched, man. You're like those surgeons that are amazing that clean up after the rest of the plastic surgeons.
Well, I don't play a lawyer on TV, but I am one in real life, which is the good news.
That's awesome.
No, definitely. And in those situations, even if it's from the seller's side and the buyer's choosing the title company, it's great to have us involved because there's a lot of title companies out there that do not know what they're doing and can mess up a deal. And when we're involved from the seller's side, we've actually had situations where we're holding that company's hand and showing them what to do for the sake of the seller's side just to get the deal closed.
Do you think it would be pretty interesting? And I've done some education on my own, but not side by side with an attorney like yourself. Do you think it would be interesting to do some educational classes? I'm not just like pitching, but again, I want agents to know that they have the ability to get the due diligence done early on if they're selling when they take the listing, and then tools to resolution and best practices because that's even though every case is different, that's how we learn.
Definitely. It's a great question. Thank you. I myself personally teach seminars on real estate contracts and closings at the real estate associations around South Florida.
That's cool.
To about 60 realtors a month. So you have to really master a subject in order to be able to teach it to others.
How do you go? It's so interesting. You'll go over like an as-is or right for sale, the two types of contracts. I'm not well versed in that, but how do you go? Like we're just talking about in this interview, one small section of that contract.
It could go on for a long time.
Yeah. But I know form simplicity and dot loop, and I'm very aware of what the real estate industry is using. The agents have been given these documents, and to to provide guidance for them that were done by attorneys like yourself.
Right, but again, a contract is a legal document, and
do you ever find a situation where you were handed over a file and they used the form simplicity or copy and pasted documents, and then you saw that it was necessary to have another one depending on your buyers and sellers' interests?
Yeah, all the time. There's certain addendums that need to be used in certain situations, and it's knowing the availability of the forms out there to use, or having to create your own custom form tailored to the situation if there's not a pre-printed one.
No, because I mean, and you know every way to get to the closing table, whether it's doing a lease back. I mean, all these, just through your experience, all these different solutions that would assist a buyer and seller based off their needs.
For example, seller financing. So there's situations where
the seller's holding the mortgage for the buyer?
Right, exactly. The seller actually holds a mortgage.
How do they go to the property? They go to the property and say, give me my payment?
Well, there you go. So how do we enforce that? How do we have to prepare a mortgage and a promosory note?
Yeah.
Are
Ben and Kevin coming over there and going to get the rent? The mortgage payment?
Our muscle is through the court system, and we allow the sheriff.
We think with our minds.
The sheriff to handle that aspect of it.
Yeah.
But for example, to your point, if you get in a situation where a buyer can't get a loan, or a buyer can get a loan but it's not enough and they need extra money, and the seller is willing to actually contribute that money, but they want to make sure that they get paid back, right? So how do they do that? We need to draft a mortgage that secures the property as collateral, so that if they don't get paid, they can foreclose on the house and recoup their money that they lent to the borrower. But you need an attorney to be able to do that and get creative and come up with the terms and be able to draft the documents that are enforceable to allow that to happen in a transaction to get it to be able to close. So that's a great example there of one solution we can come up with in getting deals closed.
And again, I mean, I just love these, talking about the best practices and what agents can do out there and how they can recommend you to just get the deal done.
Yeah, they can definitely rely on us. It gives us it gives an agent the best chance of the deal closing. Let's face it, in real estate,
I love our jobs because sometimes, again, we're brought with these hardship situations and we're able to develop solutions for all parties. And I'm kind of in I'm not saying that my job's more difficult than yours or vice versa, but I'm in a juggling act sometimes, holding the buyer, the seller, the agents, the city, all of those things, and then time frames and trying to get stuff on track.
There's a lot.
It's fun, but again, again what I've seen in the industry is copy and paste, and this is not copy and paste. Boss Construction, Plotkin Law Firm, Express Title, Reliable Lien Search, not copy and paste.
Correct.
Customized solutions to get things done.
Creative
in our weird South Florida environment.
Using expertise and creativity that is unique.
I don't want to draft an operating agreement. I don't want to go on legal docs and drop downs.
And I don't want to go explaining to an inspector why a generator
why this happened.
Exactly.
Yeah. What is this from?
So we have to work hand in hand with the professionals that are proper for the situation, and that's really what we bring to the table, is a lot of expertise and a lot of great relationships with experts like yourself. And vice versa, and we should collaborate more on speaking engagements and education.
I had an awesome time. I think you had an awesome time.
I couldn't have had a better time. Thank you so much.
Thank you so much. And on the information bottom below, you will be able to Express Title. You'll be able to ask Kevin Plotkin questions. You'll be able to talk to me and engage. We normally don't. Again, this interview went 30 minutes. We try and break this up and provide reliable content that's relevant for you guys. So again, we will continue posting reliable information to help you get to that closing table.
Definitely.
That's good.
I couldn't have said it better myself.
I like it. Thank you so much.
Thanks for having us, Ben.
Thank
we
you.
look forward
All
to
right.
working
Thanks,
more
guys.
with you.